Grant.
Thank you very much, my Lord. I was coming on to the duty which we say arises for consideration under ground 2 of our appeal. I had mentioned before the short adjournment that there is a power in section 29291 of the Act, the Guernsey Act, to issue shares, and that cross-refers to section 295, which I'm going to come back to. That power, or rather the provisions of 295, which provide for, in essence, as you'll have seen, the court will have seen, an obligation on directors to form a particular opinion. Those sections have no analogue in the English law, or or the English statutory law, I should say. But unsurprisingly, the English courts, and the Scottish courts as well, I should say, have considered the question at some length as to what duties directors owe when they have made the decision to issue new shares. And that is a question that arises independently and has been analysed independently of the proper purpose rule. So the assumption is the shares are being issued for a proper purpose, but there arises a separate freestanding duty analysed over many cases as to the nature of that duty. And what I'm proposing to do in the next 10 minutes or so is to take the court through the body of authority that has developed. We refer to it in our written case as a chorus. My learned friends dissent from that proposition, and it'll be for this court to decide whether it is or not. We very much suggest it is rather more than a chorus, but an impregnable body of authority of the highest order. I'm going to take the authorities in chronological order. My learned friends refer to an old House of Lords decision called Hilda and Dexter, which is at 2091. I'm not proposing to show the court that decision. My learned friends will make of it what they wish, save only to note that Lord Davy at page 2098, in the course of a very short, none the worse for that of course, very short judgment, explained that the case arose not as a matter of directors' duties, what the duties might be, but as a matter of companies' powers. The case has got nothing to do with the duties of directors as owed to a company, so we can push that to one side. The next case in date order is Lowry, a decision of the House of Lords from the early 1940s. It is a decision on an arcane point of, well, at least to me, arcane point of tax law, and we don't need to be troubled by the precise facts that gave rise to the appeal. All we need to look at, I respectfully suggest, is page 2153. I should say the judgment starts at page 2122, but all we need to look at, for my purposes, is Lord Wright's speech at 2153 of your lordships and my lady's bundle, where, and we're halfway down the page, where, having referred to this old case that my learned friends set some store by, Hilda and Dexter, Lord Wright says, and this is almost exactly halfway down the page, the power to issue further capital is only a potentiality, but the fact of issue makes it actual capital and creates the fasciculus, what a wonderful word that is, of rights and liabilities between the company and the shareholder, which flow from the share when issued. If the share stands at a premium, the directors prima facie owe a duty to the company to obtain for it the full value which they are able to get. It is true that it is within their powers under the Companies Act to issue it at par, even in such a case, but their duty to the company is not to do so unless for good reason. Now, that was a set of sentences within a dissenting speech, and my learned friends seek to make something of that. It is undoubtedly the case, though, that those words do not in any way stand against the the outcome of the appeal, in my respectful submission, and they have not been treated as such by subsequent courts. The next decision in time that bears on this question is the famous case of Mayor and Scottish Cooperative, which was the first case decided in the House of Lords concerning the unfair prejudice jurisdiction. It is not a case directly on the power to issue new shares, but nonetheless, in the course of his decision, a decision which I should say starts at page 2181 of the authorities bundle, Lord Denning, then not the Master of the Rolls but a member of the House of Lords, said this at page 2223, at the bottom of the page, and I don't think the facts are of any relevance, and I don't.
Is this another dissenting speech, being Lord Denning?
No, very much not, my lord. It's a fair question, but it's not. No, not a dissenting speech at all. Where he was part. Each of their lordships gave separate judgments in dismissing the appeal from the Scottish Court of Appeal, or Court of Session, perhaps. But your lordships will see, and my lady will see, that the dictum from Lord Wright in Lowry is cited at the bottom of page 2223 by Lord Denning. That's the next case. The next case in time.
Did anybody else agree with him?
Sorry, my lord?
Did anybody else agree?
No, it's fair to say that each of the 5 judges gave, I think it's fair to say, separate judgments, and the leading judgment was that of Lord Keith of Avonholme.
And he didn't address this point?
He didn't, no, he didn't.
But before you move on from in Lowry, Lord Wright appeared to be suggesting that the purpose of the issue had a bearing on the valuation.
Forgive me, my lord.
Am I not right in thinking that Lord Wright in Lowry was suggesting that the purpose of the issue had a bearing on the valuation?
Well, I think what the point I think that Lord Wright was making is that if the directors resolve to issue new shares in a company, then prima facie they have a duty to obtain the full value for them. So it's not concerned with the underlying purpose, but if that resolution has been lawfully taken, so to speak, then a subsequent duty arises, is my understanding. The next case in time is that...
Well, the words prima facie indicate that that's rebuttable?
Well, and I accept that it's rebuttable in the sense that I accept that what the cases should go on to show is that there are circumstances where it may be a proper thing to do to issue the shares at below market value. For instance, if the value of the shares stands at in the open market at £100, if the directors wish to raise a substantial amount of capital, their concern may be that if they issue a substantial body of shares at 100, there will not be a full take-up. So in that situation, it's been, I think, been recognised in the cases that maybe that would be a scenario where it would be appropriate for the directors to issue at, say, 95 rather than 100 in order to ensure a full take-up, so that the desideratum of the capital raising exercise is fulfilled. That's that kind of scenario.
And so long as their opinion about it is reasonable, the court won't second guess it.
We would say, but my learned friends, of course, say it's not the reasonableness doesn't come into it. My learned friends say, and are very, very particular about this, and they have to be given the facts of this case, that all that matters, and I'm prefiguring my learned friend's submission, but I hope it's a proper answer to my lady's question. My learned friends have to say that all that matters under this separate duty is that the directors have bona fide arrived at a conclusion. However irrational or unreasonable that conclusion, that forecloses judicial oversight or intervention.
Well,
and the body of authority...
Sorry, I do apologise. At the moment, it's there has to be a reason, unless for good reason.
Right.
At the moment, I'm struggling to see what the good reason was in this case.
Well,
no doubt
I'll allow my learned friend to seek to explain that to you.
The proposition itself is hardly one I would have thought that even needs authority. It seems fairly self-evident that you don't give the property, give money away without good reason. Well, if there's a price to be had, then obviously it's in the company's interest to to get that price. But there might be a good reason why there isn't.
Well, my lord,
seems obvious.
It's obvious perhaps to many people, but not to these respondents. My lord, can I go on? My lords, can I go on to the next?
Sorry, can I just ask one? I mean, a company doesn't actually give anything away when it issues shares. Can I suggest that the concern that's been expressed is that if directors issue shares for something less than the best price, they may essentially be diluting the existing shareholders. I mean, that's the actual concern. You don't give away stuff when you issue shares, but if you do so at less than the best price that you can obtain, i.e. an equivalent price to the value which the other shares may have, at least the assumption is you're harming the other shareholders by so doing so. And it may be that it's appropriate to do so because the company's need for cash may require you, for example, to offer a bargain, if I can put it that way, to the subscribers. But isn't that what's actually going on when your company issues shares?
That's part of what's going on. But the fact is, if you issue at nil value or some approximation of nil value, then the company hasn't received money. If you can issue at proper value, then the company will necessarily receive a benefit. So you are depriving the company and obviously, as a result, those with an economic interest in the company, i.e. the shareholders, of a benefit by issuing at nil or approximately nil value or less than market value. So there are two considerations at work which actually are mutually supportive of each other. Yeah. So I agree with my lord to that extent.
And just as a matter of note, I mean, this isn't the first unprejudiced case to come before the House of Lords because it long predated unfair prejudice.
Yes.
It's a case under the old oppression.
Yes, no, you're quite right. My lord, can I then move on to Shearer, which is the decision of Mr. Justice Walton in 1980 at page 2273, which for reasons that I'm unable to enlighten the board concerning comes from the Australian government's taxation office reports rather than the All England reports where it's actually cited. I can't explain why that is, my lord. My lady, I'll explain. I apologise for that. Mr. Justice Walton, in the course of a decision covering a number of issues, dealt with this point at page 2284, where Lord Wright's judgment, speech had by 1980 achieved the status of a classic judgment or speech, as your lordships will see and my lady will see at the bottom of 2284. His lordship cites the passage I've shown this court, and then, if I can just invite the court to then read the next two paragraphs down at 2285. Now, my Lord Legate might say this is a statement of the obvious, and I wouldn't dissent from that. But it carries with it, insofar as it is not a statement of the obvious, the imprimatur of the then consulting editor of Buckley on Companies, Mr. Justice Walton, as great a company lawyer as there ever was, one might say. And I say that because my learned friends at para 93 of their case suggest that Mr. Justice Walton erred in those paragraphs that I've showed the court. Next in time is a decision which is close to our case, a Scottish decision of Lord Easy in Petty and Thompson Petty. That is at 2335.
Sorry, page again, please.
2335 of the bundle.
Thank you.
Now, that is a case which is of close to ours in the sense that it is an unfair prejudice petition brought in the Scottish courts where there had been an allotment of shares at par below their proper value to shareholders other than the petitioners, with the result that the petitioners' shareholding had fallen from 43% to 22%, and their value fell very considerably. So we are quite close to our case here That's paragraph 9, just to set out the, I don't have time to take the court through the, that paragraph 9 sets out what had happened.
Mine paragraphs are, oh yeah, they are numbered.
I do apologise, yeah, they're very slightly,
Yeah.
Sorry, can you just give me my computer crashed at the appropriate time, or at least the screen did. Can you give me the page reference again?
the case starts at 2335. Paragraph 9 is at 2338, which is just possibly a useful jumping off point. His lordship goes on to decide, as a matter of fact, that the majority shareholders had obtained a windfall as a result, para 14. He then had to come on to decide what the proper analysis under the unfair prejudice law was of this event, this dilution of the petitioner's shareholding via an issuance of shares at par rather than at proper value. And the case is decided on this point at paras 20 to 22, page 2342 to 2343. And I'm going to canter through this if I may, but they are very, I would say, respectfully, very useful paragraphs in understanding what is going on in this case and understanding the nature of the duty that is at work. It is, I think, evident, says my Lord Easy at 20b of the page, that the issue of new shares at a price below their true worth will reduce the value of an existing shareholding unless the shareholding is increased pro rata by the addition of new shares. And that's my Lord Snowden's point, of course. There is then a very useful analysis by counsel for the petitioners, which I don't have time, but I would commend to the court, because it actually provides a rather insightful explanation of what's going on. 21, it is accordingly understandable why the practice of issuing shares at an undervalue is seen as being prima facie a breach of the director's fiduciary duties. There's then reference to Lord Wright's speech in Lowry, and then there's then, that is quoted, there's then a reference at the bottom to the purpose of the allotment in the Lowry case, which were employees of the company. There's then a reference to Mr. Justice Walton's decision in Shearer. And then we can go over the page.
Just pausing there. I mean, he talks about it being a prima facie breach of the director's fiduciary duties. I mean, put into modern English parlance, that would be a breach of section 1721F, I think.
That is a...
Which is the duty to hold the balance fairly between different groups of shareholders.
Yes.
That's the modern explanation of this, which is that you effectively are taking economic value from one group of shareholders and giving it to the other.
I have given some thought to the question of the nature of the duty in play here, because and its foundation, and it struck me that there are potentially three sort of juridical foundations or basis for it. One is the common law duty, which has found expression in the section that your lordship's just section 1721F. Of course, Guernsey being a non-codified company system, but the second is the duty to exercise proper diligence and care. I mean, in one sense, the directors know they are issuing shares. In one sense, it's capable of being analysed as a duty to actually exercise some proper care in making sure you get a proper value.
Yeah, but
that's one other way.
That just begs the question as to what proper value is.
Well, no one needs to decide precisely what the proper value in this case was, because we know what they were issued at was as far removed from proper value as it's possible to conceive.
I agree you're switching to the facts of this case.
Yes.
You may say whatever the test is, this falls below it, but just in conceptual terms, just simply saying it could be a breach for duty of care begs the question as to, what.
My Lord, I'm simply laying out for you potential juridical foundations. The third, my Lord, and I was interested in, as ever, of course, in Lord Briggs's judgment in Saxon Woods, where at paragraph 41, when analysing the nature of the duty or the nature of how duties arise. Lord Briggs said that there are bespoke duties that have been analysed in the cases pre-codification, which don't necessarily fall within any of the codified duties. And that section, I think, paragraph 41 and 42 of Saxon Woods, which I think the court has been provided by my learned friend Mr. Lightman. Going back to Petty, para 22 is a paragraph.
Care is presumably care to act in the best interests of the company. I mean, or to.
Why?
I mean, if you were able to issue shares for a large sum of money and instead you give them away, then you're just carelessly giving up an opportunity within the company to raise some capital.
And of course, I absolutely agree with my lord. And of course, the company and the shareholders for these purposes have an absolute unanimity of interest. And the company is benefiting, the shareholders are benefiting. And if the company is not benefiting, the shareholders, and certainly in this case, the minority shareholders. But the Lord Easy does then at para 22, page 2343, provide some further insights of a very valuable nature, in my respectful submission. And we see at D.
So what page number, sorry?
2343. This is para 22 of the Scottish decision. It is, I believe, inherent in the fiduciary duty to which reference has been made that prior to issuing new shares, directors should form a view as to the value of the shares which they are offering. It cannot be said that the value of a share in a company is something which must be out with the knowledge of its directors. And then I would just invite the court, so as to save me boring them with my voice, to read down to the bottom of paragraph 22, which I suggest is an extremely useful analysis. And the final, forgive me, the penultimate case that I wish to draw this court's attention to is the decision of Judge Pearl, Queen's Counsel, in Sunrise Radio from a few years back. We find that at 2460 of the court's bundle of authorities. It's a very long judgment, which actually, again, it found its way, I think, into the BCLC, the British Company Law cases, but has been given in the non-reported judgment, which is unfortunate. That is, again, another case where directors issued shares which were taken up only by one portion of the shareholder groupings, with the result that the petitioner's shares were diluted, and that was also a case where the shares were issued at significantly below their true value. And Judge Pearl had an awful lot to say and looked at the authorities in a way which I would again suggest is extremely helpful to this court. Again, I've got limited time, so I'm going to have to take this at a canter, and I apologise for that. The relevant facts can be extracted from paragraph 105 and 108 and 109, and indeed 111, which I won't give the references. 2494, 2493, 2494, 2495, my lady. Before that, his lordship had analysed the nature of the duty at work here, and again, I'm going to have to be very quick. Para 76.
On page
2483 refers to the obligation to be fair to all. Para 77, there's a reference to Mr. Justice Hoffman, as he then was.
Slow it down just a little bit. Sorry, you were paragraph 76. Which part of it? The first half, so to speak, down to the bottom of the page.
And in fact, I'm afraid, sorry to be a bore about this, but in fact, the whole paragraph really deals with it, and I don't have time to, forgive me, to. Para 79, para 77 refers to a judgment of Mr. Justice Hoffman, as he then was, which makes the point that bona fides is not an answer. And I've made that point, of course, before. Para 79 at page 2485 analyses the duty further in terms of as a fiduciary one. Paragraph 82, 2487, the propriety of the purpose is not the end of the inquiry. There's a reference to Howard Smith and Ampol there.
Sorry, which paragraph was that?
Para 82. And then para 83 and 84. And there we have a reference to the famous judgment of Mr. Justice Golding in Mutual Life, where, and again, this may be a point that my Lord Snowden has already anticipated, which is the duty to act fairly as between different shareholders. Mrs. Justice Arden, as she then was, takes up that point at paragraph 85. And then we can then charge ahead to paragraph 91, page 2490. The requirement of the board to consider all relevant matters is in line with the duty of trustees. This is picking up from what had been said in Glossop by Mr. Justice Harman, that's been quoted at para 86.
Sorry,
this is I'm sorry, I do apologise for going so quickly. Para 91, the duty to take into account relevant matters. My learned friends deny that duty, I should say, as we'll come on to see.
I thought they said it was too late for you to raise it.
Well, I'll allow that point to be made by my learned friend and reply to it as so far as necessary. Para 95, page 2490, refers to the requirement of even-handedness and fairness. Again, anticipated by my Lord Snowden. And then really the key paragraph, one might think, is paragraph 96, where we can pick it up 8 lines from the bottom. If, as happened in this case, this is page 2491, forgive me. If, as happened in this case, the minority shareholders are unable or unwilling to subscribe. Here, of course, the matter is a fortiori. They were never given an opportunity to subscribe. That was the whole point. But the majority shareholder is so willing. The duty of the directors will ordinarily be to get the best price they can from the shareholder willing to subscribe. The other shareholders will, in those circumstances, inevitably suffer a dilution in the proportion of shares held by them, but the adverse impact on the value of their shares will be minimised, if not wholly avoided, i.e. if that duty is fulfilled. And again, one might say a statement of the obvious, but nonetheless a statement very much worth making.
But why will the adverse impact on the value of their shareholding be minimised?
Oh, I tell you why, because, sorry, let me seek to explain why, rather. Because if there are 1 million shares in issue, 500 to A, 500,000
yes, sorry,
to B.
I've understood it, yeah. Sorry.
Okay, thank
being
you.
slow.
Because the company gets the money and that swells the value of the shares.
I'm glad my lady does, but I'm not sure I do, so I'd be grateful.
Sorry.
So if we have a situation where there are, let's call it 50 shares each in a 100 share issued company, they have a value, those shares. If those shares are each diluted by the issuance of another 50 shares to shareholder C, who's a newcomer, if they are issued at £0, then the value of A and B shares will have gone down by, I mean, all else being equal, by a third. Whereas if they are issued for full value, then the shares of A and B, even though they've been diluted, will have retained their value because of the company will have received full value for the shares. I think that's reflected in the way I put the point. And finally, paragraph 1116, which again I suggest that's page 2497. Now, that is a canter through the authorities, and I apologise for doing it so quickly. I can now turn to see what the Court of Appeal made of this point, and we can pick that up at paras 68 to 72. That's page 1, it's tab 7 of the blue file, and it is at pages 1842 to 1844. Under the heading, the terms of the share issue, ground 6, there is then a recital of the nature of the challenge at para 68, 1843. There's then some further facts recited at para 69. The foundation of the appeal is para 70. That's the appeal to the Court of Appeal, of course. The way the matter was addressed by the Royal Court, para 71. And then the answer that is given is confined to one paragraph, which is para 72. And I challenge the reasoning, respectfully, of para 72 under 4 headings. The first is that whilst the first 2 lines of para 72 proceed on the basis that Sunrise Radio is correctly decided, and I say it patently is with respect, that's the first 2 or 3 lines, i.e. the ordinary duty. What the court then says is this, and this is line 3, after the citation of Sunrise Radio: once it is accepted that the power to allot shares is not necessarily confined to raising additional capital, it follows logically, says the Court of Appeal, that the directors are not invariably required to obtain the best price they can. And then this, and that is not how the requirement under section 295 is expressed. We're looking at it from the common law lens at the moment, not 295 at all. There are 2 separate foundations or sources of obligation here. So quite why the Court of Appeal simply confined it to what section 295 says is unclear. But notwithstanding that point, we challenge respectfully that logical leap to, once it is accepted the power to allot shares is not necessarily confined to raising capital, ... We say respectfully that is a very difficult proposition to understand. Whether or not the share issuance, the purpose of the share issuance is capital raising or something else, a decision to issue shares to one shareholder or one shareholder grouping at less than market value will necessarily prejudice the minority shareholder, irrespective of what the purpose of the issuance of the shares is. The vulnerability of the minority shareholder.
Why do you say that? I mean, let's take the issue of shares as an incentive to employees. I mean, they necessarily, almost invariably, the issue of shares as an incentive to employees is done on highly advantageous and reduced value compared to the existing shares. But the expectation or hope is that everybody will benefit because the employees will work harder.
I accept.
If I could add to what Lord Snowden has said, that is, unless for good reason, and that is a potential good reason, as in the Lowry case.
Right.
Page 2153. And so if there is a good reason for it, well...
My Lord, I accept that the duty, there is not an absolute, it's never been our case, I should say, there is not an absolute duty in every case for directors to ensure that they obtain full value for the shares, and that's referred to in some of the cases that I have previously discussed. But that is the prima facie duty, as it's said in those earlier cases. There are circumstances where that duty might be blunted. For instance, in the example I gave of the desire to raise capital, where the fear is that if you issue the shares at market value, you won't get a full take-up. And you need to get a full take-up, so you market them at less than their market value. And another example is, as my Lord Snowden rightly says, another example would be the issue of shares in to employees in order to benefit the company overall.
For any old reason. It's got to be
a good reason.
It's got to be a good
exactly.
reason.
But this is where the parties differ. My learned friend says there doesn't have to be a good reason at all. It's nothing to do with this court to look into the reasons. Once it is accepted, says my learned friend, that the directors arrived at a bona fide decision in the sense of a genuine decision, at that moment the door comes down. You can't intervene, says my learned friend.
But I think just trying to... Is it that there has to be a good reason objectively measured by the court?
Yes.
Or is it that the directors, in exercising the power, have to genuinely believe that what they're doing is in the best interest of the company?
It is it's not a subjective test, it is an objective test, and that is stated in each one of the cases that I've shown.
Before we say objective and subjective, is the test that the directors have to believe in good faith that what they're doing is in the best interest of the company?
No.
Right.
It's not.
So,
I mean, that's a requirement, but it's not the only.
Oh, no, obviously that, if they don't believe it, then they fall at the first hurdle.
So, is it purely objective?
Well, it's because of what my Lord Legate just said, it necessarily has a subjective element, because if the directors subjectively wish to because they hate the minority shareholder, they wish to destroy him, and their malice takes over, then plainly it's not a
you say it has to be a reasonable belief as well as being a genuine belief.
Quite.
Well, or is the reasonableness or otherwise of the belief simply an evidential factor which leads the court to, that helps the court to decide whether the directors genuinely had the belief or not, or is what you're saying an invitation to the court to get involved in objectively second-guessing directors' duties?
It is, because this is because that's what decided in the Supreme Court in Saxon Woods. Although
you'll have to help me, because first of all, I haven't read.
Well, I'm not going to be able to help you.
I haven't read
today, at least, because I'm going to have to sit down.
Managed to.
My lords, can I, my lady?
Well, the Court of Appeal here in this very paragraph are accepting there's a duty of care owed, and once if that's common ground, then that requires a reasonable. There's an element of reasonableness in the test.
Except
what they're saying is that, which doesn't seem to me to be logical, is that once you accept that the reason was not to raise capital, then market value necessarily flies out of the window, which seems to me a non sequitur.
Well, I respectfully.
They are saying that it was accordingly not a breach of the director's duty of care.
I respectfully agree. I'm going to have to be quicker.
Sorry to interrupt, but I would have difficulty with it being an entirely objective test, because, for instance, if you issue shares to employees, views may differ as to whether that's a good idea or a bad idea. And so the court would be trespassing on the director's powers if they entered into an assessment as to whether or not it was a good reason.
And Section 295, to add to my Lord's point, Section 295(1)(b) says that the Board of Directors must resolve that, in its opinion, the consideration for and terms of the issue are fair and reasonable. Because what I'm concerned about is, unless I'm misunderstanding the way you're putting it, you are saying, as a matter of common law or pursuant to this statute, that there is a purely objective standard that the court will measure the conduct of the directors against.
I am.
And I have to say, I mean, when I learned company law, the thing that was drilled into you from the start is that the court doesn't get involved in the management of the affairs of every company up and down the country in terms of second-guessing the directors on purely objective standards, unless it is not a fiduciary power it's testing, but some common law negligence, i.e. the equivalent to Section 174.
My Lord, this is as far removed from a so-called managerial exercise of a managerial power as it's possible to conceive. Of course, the law is, as your Lordship rightly said it, that in terms of decisions mount, whether I enter into a contract with supplier X at 2 years or 5 years, whether I buy my feed, if I'm a feed supplier, at £8 an ounce or £5 an ounce or so on and so forth, those are decisions which the court will very rarely intervene into. But as Lord Justice Briggs said in his dissent in Eclairs, this is far from, the issue of shares is far from being...
Yeah, but you're drifting now. I mean, under your ground too, as I understand it, we're primarily focusing not upon the use of powers for proper purposes, but upon what are its essence, statutory statutory implementation of sort of the fiduciary power.
Yes, but Lord Justice Briggs at paragraph 100 is dealing precisely with such powers and saying they can have profound effects on the shareholder, the balance of power, so to speak, with the shareholder. And therefore we're not in the managerial world. And indeed, that's also what Lord Wilberforce says at page 838 of Appellant, where he says that affecting the constitutional ownership of the company is not a exercise of a management power. And my lord, I just go back to what Lord Wright said I mean,
it really matters not whether it's for your purposes. It can be entirely subjective. That is, so long as the directors have a good reason, they can sell the shares at whatever value they wish. But it's a total non sequitur to say that just because the purpose is not to raise additional capital, it follows logically that you can totally disregard the best price.
I respectfully agree, and that's my second point, which I may become an OTO's point, which is essentially what the Court of Appeal say, and I'm just following up from what my Lord has so rightly said at para 72, that once you are not raising capital, they say in terms the market value becomes an irrelevance, and that is just doesn't make any sense with respect. I'm going to just move on because I don't want to in any way trespass on this court's time. The third point, very briefly, is that it is emphatically not simply a matter of evaluation for the directors. They are not free to arrive at whatever conclusion they arrive at and simply play their trump card at any attempt to examine their reasons by saying, we genuinely believe this, back off. That cannot be right. And the fourth point, that's my third point, my fourth point, my lords, my lady, is the reliance on Ms. Whedon's 4.18. Not even, I don't think it was referred to by the Royal Court. I'm not aware that it was referred to by anyone in argument before the Court of Appeal, but it made my learned friend can enlighten me on that. But what the Court of Appeal say, oh, well, look at what Ms. Whedon says. We've looked at what Ms. Whedon says. I was very careful to show you precisely what she had.
You say it ignored the subsequent paragraphs.
Quite. My lady has it in one. And all that Ms. Whedon says at 418 is that it might be something you can, within the sort of general scope of the possibilities, to value on a cost basis. And then says, but by the way, when you do that, you've got to actually value taking into account the actual value of the subsidiaries rather than just taking some notional and frankly fictional figure in 2021 terms, which derives from events that happened possibly 20 years earlier. And that's why my learned friends stay very well away from that. I'm going to steal 5 minutes of my reply time just to wrap up. The conclusion we reach at para 131 of our case, which may to some extent answer what my Lord Snowden has raised before the short adjournment. This is page 1954 of the Blue Bundle, tab 2, is that what has happened here, let us be absolutely clear, let us not beat around the bush and engage in euphemisms here. My client's property has been expropriated, just as much as if somebody went into his house and took half his gold coin collection. That is what's happened.
It's not true. You still have the same number of shares you had before, it's just the value has been diminished.
My lord, a shareholding only has value by reference to its proportionate...
The bundle of rights that your clients had attaching to the shares that he had are exactly the same now as they were before, but they are worth a lot less.
Well, I'm not going to quibble with my lord. There has been de facto, we say, an expropriation, if not of shares, then of value. And And that ultimately is what matters to a shareholder. It's not the notional number of shares he or she holds, it's what their value is. That has been expropriated, and the proper remedial answer was stated by Lord Justice David Richards, as he then was in the case there cited. I wish to spend just a short amount of time on section 295. That is the section which, as of course the court has seen, requires the directors to resolve that the consideration and the terms of the issue are fair and reasonable to the company. Those are two separate matters. The battle line here, in essence, is does that, and this is a separate ground or sub-ground, because we primarily say look at the common law. You don't need, but section 295 has that places that express obligation on the directors. The battle lines between my learned friend and myself are, does that provide, irrespective of what the common law says, which is a separate point, that so long as subjectively the directors form a view, then however irrational, unreasonable, etc., that view may be, then it is unimpeachable under section 295. And we respectfully suggest that that cannot be correct. The purpose of section 295 was to enhance the common law, not to detract from it. If I'm right on my position on the common law, section 295 must be giving further rights to the shareholders who are affected by the exercise of the power conferred by section 291. And section 295 is there to protect the people precisely in the position of my client. Now, let us go finally to my learned friend's case, because we need to be very clear as to the extreme position that he is necessarily obliged to adopt in order to defend this judgment. I invite the court to go to page 2001, tab 3 of the blue file, paragraph 108. The test is exactly right. The test is whether the directors, in good faith, believed that the consideration and terms were fair and reasonable under section 295, or in the best interest of the company at common law, not whether that belief was objectively justified. In order to succeed on this appeal, my learned friend has to persuade this court that that is a correct statement of the law, and it's a statement, of course, it's a statement that he elaborates further on at paragraph 117.5, which I don't take the court to. We respectfully suggest that if that is the law, then minority shareholders are placed in a very vulnerable position indeed, because it means that if a board of directors decides genuinely, without mala fides, that a share issuance should be made on whatever terms they alight upon, then however catastrophic the impact that might have on the shareholders who are not participating in the subscription or the issuance, that cannot be challenged in any shape or form. That would be a very substantial decision, and it would be a decision, in my respectful submission, that would flatly run contrary to what I adhere to saying is the chorus of authority which I have taken this court through. I just end my submissions with this, just to remind the court of this conundrum. The reason the directors believed that they were justified in doing what they did, the reason they believed it was proper and fair to issue these shares at essentially nominal value to Mr. Domaille is because they genuinely believed they had set in place protections and undertakings which ensured that Mr. Sinclair's economic interests were not harmed. It has now been established definitively that that view was wrong. If this appeal is dismissed, the remarkable outcome, as it may be thought, will have been reached, that an outcome will have been achieved for the respondents which they themselves did not intend. And in fact, an outcome will have been achieved which they themselves intended bona fide, but wrongly, the precise reverse of. They thought Mr. Sinclair was protected. They intended to protect Mr. Sinclair. In fact, they did not protect Mr. Sinclair. I don't say that by way of pouring any doubt on their bona fides, but that's the reality. If this appeal is dismissed, then they will have achieved precisely what they claimed at the time they are intending not to achieve. That would be, in my respectful submission, a remarkable and unfair outcome. I apologise for trespassing on the court's. I obviously will take time out.
Thank you, Mr.
In my reply. Unless I can assist the court any further, those are my submissions on behalf of Mr. Sinclair.
Thank you very much. Mr. Lightman.
My lords and my lady, I'd like to start by clearing up what may be a misunderstanding of our case on ground one. To be clear, we are not saying, and have never said, that when asking whether a director has acted for a proper purpose, one simply asks whether the director acted in good faith in what they considered to be the best interests of the company. Obviously, they are separate duties. One can breach the first without breaching the second. Nor are we saying that when asking whether a director has acted for a proper purpose, one asks whether the director subjectively thinks that their purpose is proper. I don't want to go down the Saxon Woods rabbit hole now, but we will be referring to that judgment when we get to ground two, not when dealing with proper purpose in ground one. The respondent's case on ground one can be distilled into four simple propositions. Proposition one: determining whether there is a breach of a proper purpose rule always involves a two-stage inquiry. The first stage is identifying, as a matter of fact, the subjective purpose for which the power holder acted. The second stage is identifying whether that purpose is within the range of responses for which the power was conferred, and is a question of law. So far as I'm aware, Proposition 1 is common ground. Proposition 2: while it is impossible to enumerate all of the purposes which will be proper ones when directors exercise their power to issue shares, there are three guiding principles. First, the lodestar is whether the purpose in question falls within the sphere of activity constitutionally allocated to directors rather than the sphere of activity constitutionally allocated to shareholders. So if the director's purpose is to raise capital, to select a business partner, or to solve operational difficulties, for example, that is a management purpose, and so will be a proper one. Whereas if the purpose is to control the general meeting, control the composition of the board, or control whether shares are sold, for example, that is arrogating the role of shareholders, and the purpose will be an improper one. Secondly, if the purpose is a management matter, that is enough to satisfy the proper purpose requirement. The court will respect the judgment of the directors. It will not hold the purpose to be improper because it, the court, considers that that managerial purpose will not in fact advance the interests of the company. Third, proper purposes are not confined to capital raising, and nor should non-capital raising purposes be treated as exceptional. Proposition 3. The proper purpose rule is concerned with purpose, not effect, i.e. it is concerned with why was the power exercised, not what happened as a result of the exercise of the power. If a power holder's subjective purpose, as found as fact, falls within the range of permissible purposes, then there is no breach of the proper purpose rule, regardless of the effect of the exercise of the power. And Proposition 4, in this case it was found as fact that the director's purpose in issuing shares to Mr Domaille was to obviate the operational difficulties caused by Mr Sinclair's failure to cooperate with due diligence requirements. Solving operational problems falls squarely within the constitutional province of directors and was therefore a proper purpose. I propose to go through each of propositions 2 to 4 in turn. Proposition 1 is common ground, but first I'd like to set out the unchallenged factual findings of the courts below, since the very first question for this court, Proposition 1, is the subjective purpose for which the directors acted. Now, the company is a fiduciary services provider. As part of its operations, it is regularly required to complete customer due diligence in order to provide services to its clients. This requires the cooperation of all persons with a beneficial interest of 25% or more in the company, and we can see that from paragraph 12 of the judgment of the Court of Appeal, page 1827. And my lady Simler asked about where the requirement comes from, and I would invite your Ladyship to see paragraph 12 of the Court of Appeal judgment in that regard. Now, the findings of the jurats is to be found in the judgment of the Royal Court. And if I could take the court to page 1808, you'll see from paragraph 362 the findings of the jurats on the facts. You'll see paragraph 364, and I should say these findings, none of them are or could be challenged, and they must be taken as correct for present purposes. Paragraph 364, AHL had made multiple requests relating to operational matters to Mr Sinclair. He had received them. They were reasonable. Given Mr Sinclair's considerable experience of the work carried out by AHL, he would have understood why those requests were being made of him. Paragraph 365. Significant efforts were made by employees of AHL to explain to Mr Sinclair why the requests had been made. He did not respond at all to a significant number of requests. Now, to bring that to life, it may be useful to look at a few examples of the requests made.
Well, before doing so, was he under any obligation to do so? Was there any duty on him to do so? And apart from
he wasn't under any legally enforceable duty. Yep. If he was, then no doubt there would have been other remedies available to the directors.
Well, had he done anything wrong? In a legal sense as opposed to a moral sense?
Well, he'd caused operational difficulties for the company, which were jeopardising it. It hasn't been put as him being in breach of any enforceable obligation.
And where's the degree of jeopardy found by the Royal Court?
What they...
I think paragraph 366.
Paragraph 397.
366.
So paragraph 397 says the jurors accepted the evidence on behalf of the defendants that the operational difficulties caused by the plaintiff's lack of, this is page 1814, my apologies, the operational difficulties caused by the plaintiff's lack of cooperation was causing grave harm to the company, and that one client had threatened to terminate its relationship with the company.
Sorry, you read 367 and then you read from another paragraph.
Sorry, that's 397. Right?
Sorry?
397.
397, thank you.
Apologies. I might have been cutting across someone else when they were speaking.
366, it was put as adversely affected, so the ante seems to have been upped a bit by 397.
Yes.
You could have offered just to buy them out at a value to be ascertained. End of case.
Well, we're talking here about the company itself, the directors of the company trying to deal with an issue caused by one of the shareholders.
Yeah. He was willing to sell, you were willing to buy, and there was disagreement about the price.
Yeah. Well, my lord, there was a KPMG...
Prejudice answer, simple answer would be, here you are. We'll buy you out at whatever price is found to be a reasonable price by an independent person.
His failure to engage included his failure to engage with the KPMG draft valuation, which Mr Domaille had prepared at expense. He incurred the expense of preparing it. Mr Sinclair had refused to engage with it.
So he owes duties not just to the company, but apparently you're now putting forward duties to his fellow shareholders.
I'm not. I'm just dealing with the issue of, practically speaking, what you had to do, somebody who was not engaging.
Yeah, but you just, I mean...
You just ignore that.
I'm not putting it as high as to say he had any duty. I'm factually saying it.
The fact he doesn't engage to the other shareholder is not something the company... Why should the company be concerned about that? I mean, you added in that he wasn't engaging with...
I think that was in response to my Lord Stephen's point. It was a different point.
Well, it wasn't my positive assertion. I was trying to address the question from my Lord Stevens as to why didn't they just offer to buy him out? And the point I was saying was his lack of engagement included lack of engagement...
Yeah, but the KPMG report is just a report put forward by the majority shareholder. I mean, so he doesn't engage in... It's just standard negotiation. So why doesn't the majority shareholder just say, OK, fine, I'll buy you out at an independent valuation? That's the bog standard response to a 994 petition, isn't it?
Well, my lord, that might be a response to an unfair prejudice petition, but we're talking about
But the unfair prejudice here is due to the fact that an allegation that the part to issue shares was exercised improperly. There's definitely prejudice. And so the unfairness is, as I understand it, alleged is not using the power to issue shares properly. And so, the answer, the essence of this case is about an unfair prejudice claim. And the answer to that is, I'll buy you out. Here you are.
Well, where I was coming from was I was looking at the question whether there was a breach of duty by the directors in the first place. I'm looking at the question... the context of the director's decision in August 2020.
And what would the starting point for your argument, which you're trying to demonstrate to us, is that there were operational difficulties that were being caused by Mr Sinclair, and you need to start with that, and then you have some further steps along the way. But we shouldn't be cutting you off at the ground level, as it were.
Well, we can discuss. I'm very happy to discuss later what might have been done later. But at the moment, I'm concerned with where were we when the board made the decision, which is a central issue in this case. And the central issue was that, as I said, paragraph 397, that we were not talking here about minor difficulties. We're talking here about the operational difficulties causing grave harm.
But they're partly caused by his ill health. I mean, also in 366.
Well, it says there was no medical evidence.
I mean, but although the grave harm does seem a bit unsupported by the factual findings, because 366, 367 refer to adversely affected and operational difficulties, but where is the evidence of grave harm? Where's the fight? You know, what did the... It's all very well to call it grave harm, but what did it actually consist in?
Yes.
That was damaging in real life? Money, you know, had the value been affected? Was there evidence?
Yeah. Well,
or is it just a label, grave harm?
Well,
for
397
to describe the fact that the non-cooperation.
Well, what I was going to take the court to a few minutes ago was to actually go to examples of the of the requests made and the failure to respond and what the consequences were. I have said at paragraph 397 that one client had threatened to terminate its relationship with a fourth defendant.
Well, that doesn't sound like grave harm, a threat by one person to terminate a relationship, which apparently hadn't yet been acted on.
Well, with respect, my Lord, these are the findings of the court, which were upheld by the Court of Appeal, and my understanding, my Lord, is that that is the basis on which...
No one's doubting that there was one person who threatened to not to have any further contact with the company. But what's being asked is, how does that amount to grave harm? The threat.
Just to be fair to you, Mr. Lightman, these are the conclusions at 1808. There have been hundreds of pages before that.
Well, that's what I wanted to... I'm very grateful, Annie, because what I wanted to do was to take the court to a few examples of how the behaviour came about and what the consequences were.
Right.
And perhaps we can start with paragraph 47 of the judgment, which is page 1744. And we have a letter from Alicia Fowler, Assistant Trust Administrator at Artemis Trust, to Mr. Sinclair of the 20th of October. She requested documentation relating to the opening of a BNZ bank account. And she sent the form to him and asked him to complete it. Paragraph 48. There's a further letter from Ms. Fowler to Mr. Sinclair of the 3rd of November, saying, further to my letter of the 20th of October, please return the account form fully completed, signed and dated as requested, and a utility bill. Then, paragraph 49, we have an email from Julia Church, who was known to Mr. Sinclair, who contacted him by email and repeated the request for the form and utility bill, offered to collect it from him when ready, and she chased again on the 2nd of December. And on the 4th of December, this is paragraph 50, Mr. Sinclair finally responded. And this is an extraordinary message from someone who had been intimately involved in the business for many years. He professed to be offended that Miss Fowler had addressed him by his first name, suggested that the request may have been a hoax or a scam, stated his conclusion to ignore the request was the right one. This is an email on which the Court of Appeal placed particular reliance. At paragraph 87.3 of the Court of Appeal's judgment, which is page 1848 for your note, it said, his failure to cooperate was characterised at times by posturing. At paragraph 366 of the judgment, which is at page 1808.
Sorry.
So paragraph 366, page 1808.
Thank you.
It says, whilst at certain times Mr. Sinclair had been incapacitated by ill health, that had not been the case throughout the period during which he'd failed to respond. The directors were concerned that the delays caused by the lack of response from Mr. Sinclair were a threat to the business of AHL, and the business of AHL was being adversely affected by his lack of response. And if you go to paragraph 367, the jurats were satisfied on the balance of probabilities that the plaintiff was causing operational difficulties for the fourth defendant prior to the board meeting on, it says there, 27th of August. That's got the date wrong, 2021. Now, paragraph 384, which is on page 1812, the directors were justified, this is what jurats found, the directors were justified in holding the view that the delays caused by Mr. Sinclair's failure to respond were a threat to the business, but action needed to be taken.
So which paragraph are you reading?
Paragraph 384.
384, thank you.
That action needed to be taken to remedy the problem in the short term, and that the issue of additional shares to Mr. Domaille was the only viable short-term solution. And at paragraph 386, there's finding that the steps the directors took for share issue were necessary in order that the business would continue to thrive. That's the top of page 1813.
Just to be clear, they found that the directors subjectively believed that the issue of additional shares was the only viable short-term solution, and they found, secondly, that they were justified in taking that view.
Yes.
Or is it that the directors believed that they were justified in taking this view? Who's the they? I must admit,
The jurats.
Jurats, I think.
The jurats.
they were satisfied that the directors believed and that they would. Okay, all right.
Obviously, the directors thought they were justified. That's, I think, doesn't need to be stated. So the jurats thought so.
Well, what's meant by viable short-term solution? Do you mean it wasn't going to last for very long, or do you mean it just they had to do something quickly?
I would interpret it to mean there were, other solutions would take longer.
Yeah.
It's something had to be done quickly. There wasn't time. There wasn't time to spare.
Just would
Yeah.
sorry, I do apologise, but would the directors have been justified in having a dilution of the shares if, for instance, a shareholder had genuinely been ill or been absent or whatever?
I wanted to address that. In fact, I was about to address it now. Right. Your particular point, which, my Lord, you raised this morning.
Yes.
What's key to that is paragraph 55 of the judgment of the Court of Appeal. And that's to be found at page 1838. And there, Justice Appeal Crowe goes through each of the various alternative options on which Mr. Sinclair relied. And I should say these are ones on which Mr. Sinclair relied at trial. Not he hadn't raised them before the board meeting. And if, for example, as my Lord Stevens posited that he was ill, as opposed to non-cooperative, there could have been a power of attorney which had been executed.
If he had the capacity to issue it.
But then, well, it depends how ill and in what
Exactly
way.
so. I was just contemplating whether this power could have been used in circumstances where there was no moral fault at all on the part of the shareholder.
Well, where that...
The effect on the company is exactly the same, but the only thing that changes is that the shareholder himself or herself hasn't done anything, hasn't taken any steps that you could even classify as morally wrong.
Well, my Lord, that isn't the case in this situation.
The directors could have done exactly the same thing in such circumstances. I mean, the operational difficulties for the company would be exactly the same.
Well, the issue is that directors owe duties. Their directors' duties come into play when they have an operational difficulty, if they fail to take appropriate steps to deal with...
Yeah. Well, I think your answer is yes, that they could.
If there was no other option, then not only could they, but it might be said they had to do so to keep the company going as a going concern. It would be a unfortunate incident, and it hopefully would not be one that occurs very often. But their duty in the end is, directors can act in breach of duty by inaction, by failing to take steps to promote the success of the company. In that situation, however unpalatable, it would have been their duty to ensure the company didn't go under because one of the directors, unfortunately, was too ill to be able to address these issues.
One of the shareholders was too ill.
One of the shareholders, yes. In a situation where you've got a fiduciary services company where it depends on being able to address issues of due diligence of this nature. It's a particular form of company where this sort of issue is particularly apparent. So what happened in this, if let's say somebody was ill, but not so ill that they couldn't execute a power of attorney, if the board, and he did arrange for somebody else to sign the forms on his behalf, for example, then, and if the directors went ahead and diluted him anyway, he could then say, well, and the court would come to the view that they could have gone down the power of attorney route, and there wouldn't be a finding of an operational purpose, and there might well have been a breach of the proper purposes rule in that scenario. If the situation was extreme, then there may have to be extreme measures that the board would have to take. Now, as I said, paragraph 55 of the Court of Appeal judgment, Justice Appeal Crowe, goes through the various options on which Mr Sinclair relied. The directors could have proposed he execute a power of attorney.
Just while we finish paragraph 384, apparently the jurats found that in the last two sentences there was no intention to transfer value and that the undertakings were sufficient. What are we to make of that assessment by the jurats?
Well, the Court of Appeal didn't agree with them on the efficacy of the undertakings. So, to that extent, those findings don't survive the Court of Appeal. So that's what I have to say about that.
No intention to transfer value?
It would seem that would be difficult in the context of the requirement, the reason why it was necessary for him to be reduced below 25%.
It's quite difficult. I mean, then the question is, what is the significance of the fact that they arrived at their decision in good faith, but on a flawed basis, on the basis of fundamental misunderstanding of its effect? Do you say that has no significance?
Well, my Lord, at the moment I'm dealing with a point of law on that on proper purpose. We are.
It's irrelevant to the proper purpose point, is it?
Well, it's not. I say it's not relevant to that because the clear findings as to what the purpose of the directors was when issuing shares.
Well, their purpose was to facilitate the functioning of the company, but to do so in a way that didn't prejudice the shareholder.
Well,
to that effect, you know,
I wouldn't.
This was not to, according to this, to reduce his, to fundamentally shift the balance of power between the shareholders.
Without engaging in this debate too strongly, I would submit that this wasn't a flawed basis. They were correct. They could, in the future, issue shares to Mr. Sinclair.
Of course they could, but their whole argument was that that gave him some legal guarantee of his position, and that it meant that there was no economic effects on his interests, no prejudice to him. Well, that's what they apparently thought, even though you only got to read the letter to see that it says, well, we might think about it, which you don't have to be a lawyer to realise doesn't give you much legal protection.
Yes. Well, I'm reminded, actually, that I was going to be taking court to parts of the minutes that we weren't taken to this morning, and perhaps I can take you to it now. It's at page 1370.
Well, I'm sorry for just pressing you, but is it an improper purpose if you're avowed purpose is not to affect the share values or the value of Mr. Sinclair's shares. But that's exactly what you were doing. Is that improper purpose?
Well, the purpose was to deal with the operational problem. I haven't yet come to further analysis of that. I was doing that once we've gone through the facts a bit more. But perhaps I wonder if I could come back to that when we look at how one analyses what the purpose, the purpose was. Now, if we go to paragraph 5 of the minutes, now.
Page 1370.
Yes, paragraph 5.6 records what the directors were thinking at the time. I'm just invite the court to read that.
It's 5.6.
Yes. Yeah. And what we say is that from the fourth line onwards, all of that is factually correct.
The fact that the company didn't intend to declare any dividends isn't really much of an assurance to somebody who's not going to get much by way of dividends if any are declared. There's
a difference between saying that you don't suffer any prejudice and saying, as seems to be said here, that there's no immediate prospect that it will impact on your bank account.
All I'm trying to say is, if you're trying to see what the directors were thinking at the time of the board meeting, what they said from paragraph 4 onwards is factually correct. Whether you form the view, actually, that doesn't mean very much, or you think that means something but not a legally binding undertaking, is one thing. But I just wanted to draw the court's attention to that, and also to paragraph 5.8, which is on page 1371. That page I think you weren't taken to.
Just out of interest, what's the greater obligation on the majority shareholder?
Yes, I was following that. If you have a rights issue, you can decline politely not to take up your shares, presumably.
It just says the change in shareholding places a greater obligation on the majority shareholders, on the majority shareholder, than is currently the case. I'm just struggling to understand at the moment what greater obligation the majority shareholder was envisaged to be under.
Can you impose any duty on each shareholder to buy shares if there's a further issue of shares? I don't know.
I don't. Perhaps rather than giving an answer on the spot, which may be inaccurate, I will come back to your lordship on that. Paragraph 5.8, which is on page 1371, shows that they've taken steps to try and obtain the cooperation of Mr. Sinclair, and sets that out. And paragraph 5.10, RS had been approached a number of times to agree a valuation to enable him to sell his shares to the majority shareholder, and he's repeatedly failed to engage in this process.
Sorry, which?
Paragraph 5.10. And they noted that a number of alternatives have been discussed with Appleby to see if a solution could be found, but did not cause a reduction in his economic interest.
So why is 5.10 relevant to the directors? I mean, I think there's many authorities that say it's not. Why is it of relevance to the directors who owns the company? I mean, why are they bothered?
Well, the relevance would be that it would avoid the problem of...
it would be one solution to the fact that you can't get these documents signed off for the banks and people.
Yes.
Okay, well, if that's right, then question before, where is there any considerations to an offer being made to buy a minority out at a fair price?
Yes. Well, as I said, 5.10 says he'd been approached a number of times to agree a valuation.
Yeah, that's not what it is. Sorry, that's not the question.
Yes. Well,
I mean, obviously, in a sense, he hasn't agreed the valuation put forward by the majority. But that presupposes that that's something he's under some sort of obligation to do.
Well, he's refused to engage in a process, which is even stronger than refusing to agree. He's not engaged. as he's failed to engage with the things we've seen before. And then at 5.11, number of alternatives discussed with Appleby, and explored 2 alternatives. Appleby confirmed neither of them would be effective. Paragraph 5.12. And then paragraph 5.13, page 1372. Consequently, Appleby have advised that the only effective solution is to issue shares carrying full economic benefits to the majority shareholder if the company is to address the issue.
I do apologise. What's the AML handbook? So that is a Guernsey handbook or a New Zealand handbook? Or?
Guernsey.
Guernsey. So that's... Yeah. Okay.
Now, as I said, the Court of Appeal, at paragraph 52, in its final sentence of its judgment, which is it said at page 1837, Royal Court was fully entitled to accept that Mr Sinclair's failure to cooperate was causing significant operational difficulties and that one client did indeed threaten to terminate its relationship. It made other findings at paragraph 87, which is page 1848. That Mr Sinclair's, paragraph 87.3, that his failure to cooperate predated any serious health issues, that it was characterised at times by posturing, for example, the offence he took at use of his first name, that he was selective as to what business matters he chose to attend to. That is a reference to his being remaining a director of other non-AHL companies and attending their board meetings. He attended 17 of 18 board meetings of one company and 2 audit committee meetings in 2021. That's recorded in the Court of Appeal judgment. His non-cooperation was on occasion willful, and he appears to have been seeking to engineer a situation in which Mr Domaille was driven to make an offer for his shares which he found acceptable. Now, the final point I'd like to make before leaving the factual findings is one about the 2 other directors who resolved to issue, the 2 directors who resolved to issue the shares. Now, it's true that they were appointed to the board in July and August 2021, respectively, shortly before the board meeting, but if one goes to paragraph 167 of the Royal Court's judgment, you will see, page 1768, Ms Guillou had been a director of AHL since the 1st of July 2021, had also been the Chief Executive Officer of Artemis ATL since September 2019. In her role as Director of AHL, she is responsible for overseeing the performance of the underlying subsidiaries and safeguarding their abilities to meet their legal, regulatory and governance obligations. Whilst ensuring AHL itself meets its own legal and governance obligations, she is a qualified accountant and chartered director with past experience at board and or senior management level in a variety of industries. And Mr Bright, this is paragraph 183, page 1768. Sorry, paragraph 239 on page 1778. He'd held the position of director at AHL since the 2nd of August 2021. He joined the board of ATL on the 21st of January 2020 as an independent non-executive director, subsequently joined the board of Artemis SAL and chair of a newly established group audit committee. His role is also of an independent non-executive director. He said he'd worked in financial services for 45 years and has held authorisations for various regulatory bodies, including the GFSC. He has worked in the Channel Islands for the last 29 years and has held executive responsibility for a broad range of financial services businesses in Guernsey, Jersey, UK, and the Isle of Man. Now, I would like to also address the question which my Lord Snowden raised about the directors considering the company's solvency when deciding whether to give financial assistance for the purchase of Mr. Sinclair's shares. At page 1474 is a letter from Appleby dated the 15th of September 2021, in which they confirm that the board specifically considered the solvency position and financial assistance and provided a solvency certificate as required under section 3034 of the company's Guernsey law 2008.
Give me the number again. 1474.
And which paragraph letter?
So that's page 1474.
Middle of the page starting likewise.
Sorry.
Yeah.
And it might be worthwhile taking one further point that my Lord Snowden raised before I move on to the other propositions. The issue about where Mr. Sinclair's conduct may fit in the unfair prejudice structure of the unfair prejudice petition. Now, my Lord, were the board to be minded to allow Mr. Sinclair's appeal, it would need, I submit, to remit the question of what relief to grant under Section 350 of the Companies Law to the Royal Court. Section 351, which is at page 2031, provides that if the court is satisfied that an application under Section 349 is well-founded, it may make such order as it thinks fit for giving relief in respect to the matters complained of. Now, this is an extremely wide discretion, which would need to be exercised on the basis of all of the circumstances of the case, including the findings of this court on the issues before it, the two issues on appeal, the conduct of all the parties, including Mr. Sinclair, and the proportionality of the remedy sought for the unfair prejudice, for which the respondent, here Mr. Domaille, would be held responsible. The unfair prejudice relief, as my Lord Snowden pointed out, was the director's issue shares to restore his former stake in and control of the company. Mr. Domaille purchased his shares at a fair valuation, reflecting his ownership prior to the dilution, and damages from Mr. Domaille. In view of the findings of the jurats, it was held not necessary for them to reach a determination of a number of the questions which were put to them. And you can see that in the Royal Court judgment at page 1814. And that, you'll see the questions they didn't consider necessary. Question 16.
This is paragraph?
This is page...
1814, paragraph?
That's at paragraph 402.
Thank you.
And it's actually at the top of page 1815. It was question 16, but you'll see it at the top of the page. Has the plaintiff been responsible for any wrongdoing which would make it unfair to make an award against him? The date of valuation, that's the two down, which was question 18, to August 2021 of date of trial. And question 20, which was unagreed, which was, if the jurats find the defendants have taken all steps to ensure no prejudice was suffered by the plaintiff, yet still find the issuance of new shares was unfair and prejudicial conduct, is it fair and proportionate to grant any of the relief sought? So the Royal Court failed to address or adjudicate on the arguments against the making of a share purchase order, which were made, and for your Lordship's and Ladyship's note, is at paragraphs 147 to 153 of the Respondents' trial bundle. That's page 631. I won't take you to it now. Now, in his written case, Mr. Sinclair asserts at paragraph 132 that he is entitled to a buyout order or equivalent relief, with its terms to be determined by remitting the case to Royal Court. But Mr. Sinclair, this is on the hypothesis that his appeal is allowed, he's not entitled to any relief at all under Section 350. As we've seen, it's a purely discretionary remedy. And the propositions which he's put forward at paragraphs 136, 2 and 3, and 164 of his 24 of his written case are less straightforward than he presents them to be. Unlike in Eclairs and Tian Rui, The relief he's seeking is not confined to simply seeking declarations that the challenged exercise of a power or share issue is void, but he's seeking a share purchase order on favourable terms. And if I can just take you to divider to authorities page 3161, which is a passage from Robin Hollington's book on shareholder remedies, which is cited in Mr Sinclair's written case. The court is not engaged in a balancing exercise of weighing one side's misconduct against the other, but the petitioner's misconduct.
What page?
So this is page 3136. Sorry.
3136.
Yes, of the Apollo Authorities bundle.
Presumably it would follow at least that if the power was improperly exercised, that the exercise was invalid, and therefore the present position would be he'd have his previous shareholding back, so they'd be locked in the same situation as before.
Well, the court has to decide if there has been unfairly prejudicial conduct, what's the appropriate remedy.
But the starting point is that if there's been an improper exercise of the power, that presumably then that is voidable, isn't it?
Well, it's a question of the court having deciding whether to make an order at all, and that's the point I was going to come to, and if so, what order. And
this was the point I was trying to raise this morning, probably not very well, but generally speaking, if you exercise a power for an improper purpose, the consequence is either said to be void or certainly void ab all. And I'm uncertain at the moment why you would be able to say, in response to a finding that the power had either resulted in a void issue of shares or a void ab all issue of shares, but nonetheless it could stand because of some other factor. Because, I mean, if, for example, if you brought your action seeking to have the issue of shares declared void because the power was exercised for an improper purpose using the procedural route in Tianru, whatever it's called, Tianru, it wouldn't be able to be said against you, yes, but it's unfair. So you say, but a different result follows if the proceedings are unfair prejudice proceedings. Well, there the court can say, yeah, okay, well, we know the power was exercised for an improper purpose, but nonetheless we won't do anything because it's not unfair to you.
Well, look, I'm not running a separate point on unfairness. I'm talking here about remedy.
Well, yes, but you see, in a sense you are, I think, because you're trying to say it would be open, because I think you pointed out that one of the issues that hadn't been determined was the question of whether, in light of the findings, it was unfair. So aren't you just trying to preserve your right, when the matter is remitted, to run just that argument?
Well, that's an issue that hasn't been determined. My point is that...
But I mean, are you saying that if this board was to say the power was exercised for an improper purpose, and prima facie the issue of shares was either void or voidable, that you'd say when it was remitted on that basis that you would then reserve the right to argue that, notwithstanding that, it isn't unfair to Mr. Sinclair?
Well, I'm not arguing. What I'm coming to is the point, because we're not raising separate arguments about unfairness.
Not here, but I'm just asking you whether you're reserving
the point we're looking at
those arguments somewhere else.
Well, the simple point I was going to make, my lords, they're not seeking to set aside. That's not relief he's seeking. He's not seeking to set aside the share issue. That's not relief he sought in the petition.
Well,
what he's seeking is to use it as a...
He has, and if there is a finding that it was improper, isn't the inevitable result that it's set aside? And then why remit that to the Royal Court?
They may still have to decide whether to order a buyout or something, but that's a further question.
Well, put it this way, that's not a remedy he's seeking. It might be a remedy that the court orders.
Yes, and there's no objection to that.
The court the court has a range of, there's a very wide discretion as to what order to make, such order as it thinks fit.
If we found that it was for an improper purpose,
yes,
is it appropriate for us to set aside that issue of the shares?
Well, that might prejudge what remedy the court should give, because if you set aside...
On what basis could we not set it aside?
If
it was improper.
If you might, for example, decide that it was, for example, on that hypothesis, in breach of duty. As to what remedy, what the consequences are, that should go to the Royal Court. The difficulty is, if this court sets aside that transaction, it might be that is actually the remedy that the Royal Court would give at the end of the day. It might be that the petitioners don't actually want it set aside, because they actually want a share purchase order on the and they want to be issued further shares to make themselves...
They want to share... I mean, I'm sorry, I'm just struggling to find where the petition is, but it's...
644. But...
it's on the basis... the remedy is presumably sought on the basis that...
the shareholdings were as they were before they were altered.
Correct.
Well, they want to be issued shares to restore...
Well, that's another way, but that's rather... Yeah. The shorter way would just be to undo what had been done, rather than
I hesitate to say it, but isn't it a bit like jaundice against jaundice? You want to purchase the shares, they want the shares to be purchased. And so, as I understand it, and but for some reason one's got to remit the whole thing to the Royal Court. To do what? If in reality the desire of your client is for the shares to be bought out, but why not just say so? And we can cut that Gordian knot.
Well, clearly, overnight we will hear what you said. I'm not in a position to respond about present intentions of my clients.
Yeah.
My point is simply this: that the relevance. I was trying to respond to the point that my Lord Snowden was saying. Well, where does Mr. Sinclair's conduct come in here? And what I was going to say, as Mr. Hollington casely pointed out, in paragraph 7.84 of Hollington, which is page 3136 of a Policy Bundle, is that the court is not engaged in a balancing exercise of weighing one side's misconduct against the other.
Forgive me, 3136, which paragraph? Where on the page are we?
It's bottom of the page.
Thank you.
The last three lines.
The equitable doctrine of clean hands.
But the petitioner's misconduct is relevant if it has an immediate and necessary relation to the unfairly prejudicial conduct of which complaint is made. And we would say that his non-cooperation led to the board meeting, which is the unfair prejudice of which he complains.
But there could be different kinds of unfair prejudice, can't there? And here we're concerned with a specific question of whether the powers were exercised improperly, but you say it's all just the same, is it?
Well, I would say the court considers, when it exercises its wide discretion under section 996, it looks at all the circumstances of the case. And that includes any conduct, relevant conduct of either party. It also is...
Does that mean that when you say relevant conduct, you've accepted that Mr. Sinclair has not committed any wrong? He's not done anything wrong. He's not breached duty. He's just been difficult.
Yeah, well, he's difficult.
Uncooperative. All those other sort of epithets that we could have thrown. And you say that fits within the discretion of the court. In a case where, on this hypothesis, the response of issuing shares has been found to be for an improper purpose, that the court could nevertheless come to a decision that it was appropriate not to grant him any relief.
Or it might be that it orders a setting aside of the share issue. It might decide that is the appropriate and proportionate response.
Then you're back to square one, aren't you?
Well, the court, the jurors would have to form that decidecision about it.
If they set aside the issue of the shares, he's a 49% shareholder and he has to sign all your documents.
Well, there are going to be all sorts of other determinations that the court will have to make anyway. Data valuation. Yeah. Whether his shares should be subject to a minority discount, and if so, what discount? The methodology of valuation. There was a dispute between the parties at trial about that. Whether, if so, there should be an uncertainty discount. That was another issue which was raised at trial, and again, not determined by the jurats. It's not a question here of this court being in a position to determine the precise terms of any share purchase order. That would have to go back to, I submit, to the Royal Court. And it would be appropriate for the Royal Court to exercise the discretion under Section 996 with knowledge of all, if it was in that hypothesis, with knowledge of all the circumstances of the case. And I should add that it's not as if Mr. Sinclair subsequently repented of his position. If you go to page 606, this is paragraph 104 of his skeleton argument for trial. The court will be invited to find that the defendants have failed to adduce any cogent evidence that any step was in fact needed. Although he was temporarily hindered by his illness, Mr. Sinclair took all reasonable steps within his power to cooperate. There was no genuine, insurmountable obstacle to the conduct of the company's business. So, total denial that he'd caused any difficulties, or that there was any need to take any steps. I've had this quite lengthy diversion because I wanted to try and deal with my Lord Snowden's point, and to say that whilst this court clearly decide, if it were to allow the appeal, what it would decide to do, there are various different options as to what a court might do in these circumstances, which are not limited to a share purchase order, and could be the court looking at all relative culpabilities for the state of affairs which have arisen, which might require some careful consideration. If I can move on to if I may, since time is ticking, to the second proposition, which is the lodestar for whether a director's purpose in issuing shares is permissible is whether it was a management purpose. This proposition is best illustrated by Howard Smith and Appellant. Now, you were taken to it very briefly by my learned friend, but I'd like to take it a bit further. It's at page 2255 and following. And what happened if we go into page 2265?
Page?
So page 2265, findings of fact. Lord Wilberforce starts with the question of fact, namely, what was the director's purpose in issuing the shares to Howard Smith? And at line G, Mr. Justice Street considered the main issue being to ascertain the substantial object, the accomplishment of which formed the real ground of the board's action. At page 2267, line D records Mr. Justice Street's finding that the management's primary purpose in issuing shares was to enable the Howard Smith takeover to proceed. And it's clear from the headnote, if we go back to page 2255 for reference, I may not be able to have time to take you through all the detail. The existing shareholder majority, Ampol and Bulk Ships, had said that they would reject any takeover offer by Howard Smith. But with the issue of shares to Howard Smith, the interests of Ampol and Bulk Ships were diluted to 36.6%, so the Howard Smith offer could proceed.
But doesn't this raises the question of how far you look? Because if you'd asked the directors, well, why do we want Howard Smith's offer to proceed? They wouldn't have said it's because we're best friends with Howard Smith. They would have said because that's a higher offer. They want to make a higher offer for the company, and it's going to be in the company's best interests to be able to accept their offer. So what is the difference between that and this case, where again, you seem to be where there's a basic realignment of the shareholdings, but you're saying, oh, well, it's all right, because the directors had the higher end of the company's good in mind beyond that. I mean, they're always likely to have the company's good at the far end of what they're looking at. The question really is, isn't it, whether on the way to that, you can think that it's within your powers to realign the shareholdings.
Well, in Howard Smith, the directors issued shares to Howard Smith, so its offer to purchase further shares could proceed.
Yes, and then if you ask, well, why do you want their offer to proceed, they would have given an answer, I suspect, much like the answer these directors are given. I think on the facts, Howard Smith wanted to make a higher offer. and it was being blocked by Ampol and bulk ships, wasn't it? And so it's the company's benefit to be able to accept Howard Smith's offer. It's a bit like the obstructive behaviour of Mr Sinclair. Ampol and bulk ships were obstructing the benefit of the company in getting a high offer.
Yes. Well, at page 2271, bottom of the page, Lord Wilberforce makes clear that the right to dispose of shares at a given price is essentially an individual right to be exercised on individual decisions.
Sorry, what page?
Page 2271, bottom of the page.
271.
227.
2271.
2271.
Yes.
Okay.
Individual right to be exercised on individual decision and on which a majority, in the absence of oppression or similar impropriety, is entitled to prevail. Directors are, of course, entitled to offer advice and are bound to supply information relevant to making such a decision, but to use their fiduciary power solely for the purpose of shifting the power to decide to whom and at what price shares are to be sold cannot be related to any purpose for which a power over the share capital was conferred upon them. Now,
so, I mean, just see if I understand, and correct me if I'm wrong. The issue of the share capital here was, as my Lord Legate has said, was to enable the company to achieve a higher offer. Is that right? That was in the best interest of the company, and but it involved shifting the power to decide to whom and at what price shares are to be sold. What's the difference between this case and the present case? I'm just struggling at the moment, and I may have totally misunderstood Howard.
Well, in this case, as we've tried to say, the company issued shares in order to deal with operational requirements.
Yeah.
It wasn't. It wasn't in order to deal with a problem that had arisen. The aim wasn't as in this case, to enable a new party to come in and to take over the company. It was to deal with the operational problem which had arisen.
Well, that was the reason they did it, but what they had to do was to dilute Mr Sinclair to less than 25%. That's what they actually were attempting to achieve. That was the necessary requirement to avoid using words like purpose and everything else. The one thing they had to achieve was to take him down below 25%. Why wasn't dilution of his shares to below 25%, thereby shifting the balance, constitutional balance between shareholders, their purpose?
Well, my Lord, in all of the cases where the director's purpose in issuing shares has been found to be improper, that's because they've wanted to alter the balance of power between shareholders for the purpose of arrogating to themselves some function which was within the constitutional province of shareholders. For example, appointing or removing directors, that was in Fraser and Piercy, or controlling votes in general meeting, that's the Eclairs case, or amending the Articles of Association, that was the Punt case, or controlling at what price shares are bought and sold, and that was the Howard, Smith and Ampol case. It is not the altering of a shareholder's interests per se which infringes the proper purpose rule.
No, but they had to ensure that he did not have the rights of a 25% shareholder. In other words, and plainly the 25% requirement is not set just randomly with a finger in the air. It's very deliberately done because that's the threshold at which shareholders can block special resolutions. And the one thing that they were seeking to do was to dilute him, Mr Sinclair, so he couldn't do that.
Well, what we say is the director's purpose was to obviate the need for Mr Sinclair to have to comply with the DD requirements, and so remove the threat to the business posed by his non-cooperation.
Well, as my Lord Legate put it to you, I mean, that's the longer, higher justification for it, but it's not the purpose.
Well, that was the purpose as found by the courts here. In this.
That assumes they understand what legally is meant by purpose.
Yes. I'm reminded of the case of Mills and Mills, where an avowed part of the director's purpose in issuing shares was to increase the interests of one group of shareholders, the ordinary shareholders. That per se didn't make the purpose improper. It was necessary to examine why the directors were doing it. And they were doing it to ensure that the ordinary shareholders received profits on the winding up, not to increase their voting power. And so it was held that there was no breach of the proper purpose rule in that case.
I suppose what this case raises, may not be raised by the earlier cases, is whether if you fundamentally shift the balance of power between shareholders, that is intrinsically outside what the constitutional province of the directors is, and it doesn't matter that they may be doing it because they, for what reason they're doing it.
Well, that's the question. The question is for example, Piercy and Mills, Mr. Justice Peterson said, this is page 2120, directors are not entitled to use their powers of issuing shares merely for the purpose of maintaining their control or for control of themselves and their friends over the affairs of the company. There's a personal, usually there's a personal, in a lot of the cases, there's a personal motivation behind it.
Yes, but that's found not to be necessary, as in the Howard Smith case. But the point is, why isn't it beyond what you think that you wouldn't expect, would you, the directors, whose job it is to run the business, to have within their powers the ability to fundamentally restructure the shareholdings, whatever reason they think that might be desirable for, really?
Well, Mills is a case where they did so, and the courts upheld it. I don't know whether it would be worthwhile seeing that case. But if you're in a situation, as they were here, where they had no alternative, it would seem a hard thing that the directors would not be in a...
But it doesn't seem that hard to me if the other side of the coin is a fundamental redistribution of wealth amongst the shareholders.
Well, my Lord, if that, we're saying that wasn't the purpose behind it. Perhaps we can go to Mills and Mills if we can.
Well, it may, you say it wasn't the purpose, but you have to accept that it was a deliberately intended result.
It was a consequence of the attempt.
No, it wasn't just a byproduct, though. It was a necessary and intrinsic thing that had to be achieved in order to achieve what you say the higher purpose was.
I'd have to accept that, yes, my Lord. Can we just go to Mills and Mills? So,
just out of interest, sorry, just before we leave Piercy and Mills, I thought Piercy and Mills had held that it was not open to the directors to convert the minority into a majority solely for the purpose of defeating the wishes of the existing majority. And they issued shares to convert a minority into a majority because they didn't like the existing majority. Are you saying that's different because it doesn't have some higher purpose, or I'm just not sure?
Yeah.
I mean,
Well, what in those cases, in that case, and perhaps I'm repeating what I said before, the purpose was improper because they wanted to alter the balance of power between shareholders for the purpose of giving themselves some function within the constitutional province of shareholders. And I say that is why this case is different. They weren't doing it because they wanted to control the votes in the general meeting or to appoint or remove directors, to amend the articles, to take any other steps which would be consequential upon the balance of power between shareholders being disturbed. What they wanted to do was to change the balance of power between shareholders so that it could comply, the company could continue to address, could address these serious difficulties it was facing. It wasn't because it wanted to somehow use that as a first step to then...
So you're saying, suppose you just got the board of directors. They want to put some managerial proposal through. The majority shareholder says, no, I own the majority of shares in this company, so if you would put it to me in general meeting, I'll vote it down. And the directors think, well, we know what's best for the business of the company. That majority shareholder's just being obstructive. So we're going to issue some shares to the minority, who are favourably inclined to us, to take away the majority currently possessed by that shareholder, turn him into the minority, because we believe it's in the interest of the company to get on with this thing that we believe is right. Is that legitimate?
Well, in that case, what the board is doing is it's trying to denude the majority of shareholders of the right to disagree with them on and to oppose something which the board wanted to do, which presumably would require the approval of the shareholders, because otherwise the position of the shareholders wouldn't be material. I mean, shareholders can't vote down management matters. These are matters which are left to the board, and they can replace the board, but they can't interfere in the management of the company. I've been reminded by my notifier that it is now past or around 4 o'clock.
Yeah. Well, we might leave that one hanging in the air until tomorrow morning, but we'll resume at 10:30 tomorrow morning, please. When Mr. Lightman, you'll have until my calculations until 12:40.
I'm grateful.
Well, we won't fall out over that. Not at this stage, anyway. Thank you all very much. Of course, now adjourned.